And we're back here on Open. Daren Jaime here with you as we continue our coverage, talking about COVID-19 and how it is actually affecting New Yorkers. And New York and federal governments have also issued some laws that are granting immunity for liability for negligence when it comes to healthcare providers and pharmaceutical manufacturers. However, the immunity does not cover misconduct or negligence, and it would cover harm that comes from a shortage in staffing or protective equipment. And as always, we bring our legal analyst, David Lesch, in to join us. He's also the host of today's verdict. And David, good to have you, brother.
Always good to be here, Darren. You know, this nursing home fiasco, which is really the epicenter of the coronavirus in New York, has brought on a tremendous debate. About 2 weeks ago, Governor Cuomo finally acknowledged that nursing homes were no longer going to take any patients from any hospitals before the hospitals checked to make sure that the patient was not COVID-19. And that probably should have been done at least a month, maybe a month and a half ago. But now we know that you as a hospital cannot release a patient to a nursing home unless that patient has been cleared. Many people said, well, you could have released these patients a month and a half ago to vacant buildings where they could have all been on the same floor together if they all had COVID-19. They didn't do that. A lot of people feel that in itself is grounds for a lawsuit. Well, Governor Cuomo, knowing this, created what's called a qualified immunity. It's a limited immunity. And basically what it means is you will not be able to bring an action against a nursing home for the result of a death of a loved one unless you can show that there's gross negligence, a willful misconduct, reckless. It's a very high threshold. And it basically will protect the nursing homes because the nursing homes can say, hey, it's not our fault. They were released by the hospital. How did we know that they were COVID-19? We didn't know for certain. And to be quite honest with you, we were short-staffed. Essential workers were just starting to be known as to who they were. So you can't bring an action against us. Well, what would be considered gross negligence or what would be considered willful? Maybe allowing staff members in that they knew were infected or they should have done some type of screening themselves. That would be gross negligence. That would be maybe almost willful. That could rise to that level.
But I want to just jump in here for a minute and talk about families for a minute, because as the governor has increased that threshold, and it does protect nursing homes, and it does protect them. On the other side, if you're a family and you're experiencing some challenges, it looks like from a family's perspective, you got a major uphill battle in order to make this happen.
Well, you
And
do.
if you're bringing a legal action.
You do, but nursing homes are different. They're different. There are different nursing homes out there. Some nursing homes have taken some precautions. Some nursing homes may not have. Some nursing homes may not have had enough staff. Some nursing homes may have allowed staff to come in knowing that they tested positive for COVID-19, just because they needed people to come in and do the shifts. That would be willful. That would be reckless. That would be gross negligence. You would be able to have an action with respect to that type of issue. Now, some states have gone farther, Darren. They've actually issued what's called a sovereign immunity. That means total immunity. No gross negligence, no reckless, just you can't bring an action against a nursing home or somewhere else. That's called sovereign immunity. We didn't do that here. We did what's called qualified immunity. So qualified immunity will basically shield the nursing homes to an extent. So you have to understand that if you do think that your loved one passed away and there was gross negligence, not just negligence, gross negligence, you probably would be able to bring an action. And there are attorneys out there who are creating class actions so that, one plaintiff will be the head of the class, and they go against a group of the nursing homes, which, by the way, are private. These are private nursing homes. This isn't public. These nursing homes are in the business of making money. So it's very, very important that you understand what your rights are when it comes to this. And it's all unfolding. And you're going to have a time to do this because the
Right.
statute of limitations will still be 3 years. But you definitely want to get as many records as you can get and
Mhm.
patient files as you can to protect yourself, which leads me, by the way, to an interesting interview that I just recently did for the Gothamist. As
Yeah,
we're
let me jump in because I wanted let me lead in. How about that one? But I do want to talk about that. I did because as David's getting ready to talk about an interview that you did talking about basically another lawsuit that deals with false imprisonment, right? Or
that's right.
other quarantine.
It's related to the nursing home issue because it goes to whether or not you would be able to bring an action. What's the threshold for a set of facts? And these facts are different. What if there's contact tracing? They find out for certain that you are COVID-19 positive, and now the city, the state says you must stay in. You have to be quarantined, and they don't let you out. And that happens in certain places. You could be in a certain halfway home. You could be in you could be in a homeless shelter. You could be in a place where they said you're not allowed to leave. Literally can't leave. Now that the time is up, the 14 days, and you want to bring an action for false imprisonment. Your mental state has been horrendous during the 14 days. It's contributed to a psychiatric condition. You've been falsely imprisoned, just as if you're falsely arrested and
Mhm.
imprisoned for 14 days. You're imprisoned. Well, here's the thing. Yes, the law seems to suggest that you can, again, if it's reckless and willful. Well, what does that mean? Well, let's say your particular group, your ethnicity, your religion has been targeted. Only the Orthodox, only the African American community, only the Latino community. They've been targeted so that your group has been forced to stay in if you've been tested positive. We see you at religious functions in Brooklyn. Therefore, we're going to find out where you are and we're going to quarantine you. Just you, just the Orthodox Jews, just this particular group in Harlem, or just someplace else. That would be willful. That would be reckless. You would be able to bring an action there. So I think we could see that in the future. And that's what the Gothamist really was asking me questions about. They weighed in with a professor from Fordham as well, constitutional law. This is an interesting time. Many of our governments are trying to shield themselves from potential lawsuits, and they are coming, Darren. I mean, we have 100,000 people have died in this country. You can't tell me it's all an accident and all nothing could have been done to have prevented it. Their
Right,
lawsuits will be here for decades. And the
right.
question the question is, what's the threshold that a lawyer has to meet to be
Well,
able to bring?
yeah, and let me ask this question. When you talk about a lawsuit, right? We understand that if a lawsuit is brought against the state, obviously the state has to pay that lawsuit. The insurance company is going to pay that lawsuit. We know that the state is already broke as it is. We've been hearing that from time and time again. So, is increasing the threshold, making these higher thresholds, a way of not just protecting nursing homes, but actually a way of protecting the state? Because that's what a lot of people feel like. The state is going to do everything that it has to do in order to protect itself for making sure that they're not paying out anymore because they spend a lot of money on ventilators, much needed. But how much more can one state be able to handle? And those lawsuits would just cripple.
That's right. Well, that's true, and that's the other side of it. And that's why they're saying you can sue only if it's gross negligence, really reckless and willful behavior. Just negligence? No. You didn't buy enough ventilators. You didn't realize it. It was really more negligent because you thought the shipment was coming from one place, but it came from the other place. But you made it the effort to get the ventilators in. Well, wouldn't that just be negligent? It's negligent. You should have realized it, but it wasn't willful. It wasn't. I don't care. We have enough ventilators. What you know? What they'll share what they have. You know what? They'll make use of it. One ventilator for three people. We'll make it work. Well,
Mhm.
that would be willful. That wouldn't be negligence. But you're right. It comes from taxpayer money if it's the city or the state. We don't want to waste that money. We need that money for so many other things. Private insurance companies, well, that's what you insure, institutions for, private nursing homes for their negligence. But will they cover them for gross negligence, willful, reckless? Maybe not. So there may not
Mhm.
even be money there to cover them to begin with. I don't take
Right.
visits in my office where many times I don't take cases where insurance isn't there because it's very difficult to actually get the money in the pockets of my client. So
Yeah, a lot to think about. Listen, I got less than a minute, but I want to ask you this question. Talk about court systems. What are we hearing in terms of opening back up? I know that you've got an administrative judge that's actually handling business on a day-to-day fashion. What are
that's
we
right.
hearing by way of courts?
It's funny. I started with you. When we first went into lockdown, I remember you were my first interview that I did, and I told you we were doing remote at home. Well, since that time, we've been doing a lot of virtual depositions. Even many, summary jury trials we've been doing. I've had virtual conferences all day long, and it looks like, from what I hear, somewhere around June 15th, judges will be reporting back to their courthouses where they will actually be mandated to actually be there, not just some judges who are doing conferences. So it looks like June 15th, things are starting again, Dara, but that doesn't mean we're going to get 100 lawyers in the courtroom anymore. They're going
Right.
to be spacing things out. This is freely flowing, up in, where you are, up in, or in different places upstate. It's like the test model, and we're going to see how it goes. And then from there, Bronx County is going to take a look at it, and we're going to start implementing it in the next couple of weeks. That's the word on the street.
Well, we have to leave it with the word on the street. We've got the word from David Lesch as well,
Right.
our buddy, host of today's verdict, and also our legal analyst here on Open. David, thank you so much for being with us.
All right. It's my pleasure as always, Aaron. You stay safe.
Hey, you stay safe too, buddy. All right, listen, everybody, stay tuned. We still have more show here on Open. Don't go anywhere. We're coming right back right after this.